Members of the jury, we are about to start the trial of this case about which you have heard some details during jury selection. Before the trial begins, however, there are certain instructions you should have in order to understand what you will hear and see and how you should conduct yourself during the trial. The party who brings a lawsuit is called plaintiff. In this action, the plaintiff is the one who sues to recover for damages. The party against whom the suit is brought is called the defendant. In this action, the defendant is the one being sued. Defendant claims third parties are responsible for the occurrence and has brought an action against them. In this case, you will decide only the question of liability, that is, which party is responsible for the occurrence that brings these parties to court. There will be no testimony or mention of any injury, and should any person mention injuries or medical treatment, I direct you to disregard it. You are being called upon to decide only the question of negligence or fault. In this case, you will decide only the question of damages. That is, what amount of money will fairly and justly compensate the plaintiff for all those losses resulting from the injuries he sustained. Since the question of liability has already been decided, any evidence concerning how the accident happened will be received only on the question of damages. When I have completed these opening instructions to you, the attorneys will make opening statements to you in which each will outline for you what he expects to prove. The purpose of such opening statements is to tell you about each party's claims so that you will have a better better understanding of the evidence as it is introduced. What is said in such opening statements is not evidence. The evidence upon which you will base your decision will come from the testimony of witnesses here in court, or in examinations before trial, or in the form of photographs or documents or other exhibits introduced into evidence. Plaintiff makes an opening statement first and is followed by defendant. After the opening statements, plaintiff will introduce evidence in support of his claim. Normally, a plaintiff must produce all of his witnesses and complete his entire case before the defendant introduces any evidence, although exceptions are sometimes made to that rule in order to accommodate a witness. After plaintiff has completed the introduction of all of his evidence, the defendant may present witnesses and exhibits. If he does so, plaintiff may be permitted to offer additional evidence for the purpose of rebutting defendant's evidence. Each witness is first examined by the party who calls that witness to testify, and when the opposing party is permitted to question the witness, that is final. At times during the trial, an attorney may object to a question or to the introduction of an exhibit or make motions concerning legal questions that apply to this case. Arguments in connection with such objections or motions are sometimes made out of the presence of the jury. Any ruling upon such objections or motions will be based solely upon the law, and therefore you must not conclude from any such ruling or from anything I say during the course of the trial that I favor either party to this lawsuit. After such a ruling, you may hear one of the attorneys taking what we call an exception to it. Exceptions have nothing to do with your role in this case, and I mention the procedure to you so that you will not be confused if you hear the word during the trial. Upon completion of the introduction of evidence, the attorneys will again speak to you in a closing statement or summation. In summing up, the lawyers will point out what they believe the evidence has shown, what inferences or conclusions they believe you should draw from the evidence, and what conclusions they believe you should reach as your verdict. What is said by the attorneys in summation, like what is said by them in their opening statements or in the making of objections or motions during the trial, is not evidence. Summations are intended to present the arguments of the parties based on the evidence. Under our system, the defendant sums up first, followed by the plaintiff. After the summations, I will instruct you on the rules of law applicable to the case, and you will then retire for your deliberations. Your function as jurors is to decide what has or has not been proved and apply the rules of law that I give you to the facts as you find them to be. How's that?
It was fun.